If you're planning to apply for a U.S. visa, adjust your immigration status, or sponsor a family member in 2025, stop everything you're doing right now. What I'm about to share could be the difference between success and failure in your immigration journey. The rules have changed dramatically, and if you don't know about these updates, you could be setting yourself up for serious problems. I'm talking about processing delays that could cost you years, policy changes that might disqualify you overnight, and new requirements that are catching thousands of people completely off guard. This isn't fear-mongering, this is reality. And by the end of this video, you'll know exactly what's happening, and more importantly, what you need to do about it. Welcome back to Dream Visa Updates, where I cut through the confusion and give you the real facts about U.S. immigration. No fluff, no guessing, just the information you actually need. And trust me, today's update is one you cannot afford to miss. Here's what's happening right now. The immigration landscape in 2025 has been completely transformed. We're seeing the fastest policy changes in over a decade, processing times that are breaking records for all the wrong reasons, and enforcement measures that are affecting nearly every category of visa applicants. Whether you're a student, a worker, someone trying to bring family members to the U.S., or anyone hoping to come to or stay in America, these changes are going to impact you. And here's the thing that nobody's talking about. While all these policy changes are rolling out, USCIS is drowning under a backlog of over 11 million pending cases. Let that sink in, 11 million cases. So you've got stricter rules on one side and massive delays on the other. It's like being caught between a hammer and an anvil. But don't panic, because I'm going to walk you through every single major change, explain what it means for your specific situation, and give you the action steps you need to take right now. So let's dive in. First, let's talk about what's changed at the policy level since January 2025. When President Trump took office, the administration moved fast. And I mean lightning fast. Within weeks, we saw a complete reversal of the previous administration's approach. The focus shifted hard toward what they're calling faithful execution of immigration laws, with a heavy emphasis on enforcement. One of the first moves was revoking several executive orders from the Biden era that had provided protections for certain immigrant categories. Then came the creation of new Homeland Security task forces designed to increase enforcement activity across the board. What does this mean for you? It means heightened scrutiny on every single application. It means longer review processes. And it means you need to make absolutely sure your documentation is flawless. But wait, it gets more complicated. There have been major changes to public benefits access for immigrants. If you're a lawful immigrant, even if you're a refugee, an asylum seeker, a trafficking survivor, or someone with temporary protected status, you now face restrictions on accessing programs like Medicaid, Medicare, and SNAP food assistance. These restrictions are rolling out on different timelines, which is creating massive confusion about who can access what. And here's where it gets really tricky. The administration is working on a new public charge rule. If this gets finalized, it could make it significantly harder to get a green card if you've used certain public benefits in the past. So if you're in the middle of an adjustment of status application, you need to be incredibly careful about every decision you make regarding government assistance programs. Now let's talk about something that's affecting hundreds of thousands of people right now: temporary protected status. If you have TPS or you know someone who does, pay very close attention to this section because time is running out. TPS is a humanitarian program that allows people from certain countries experiencing armed conflict, environmental disasters, or other extraordinary conditions to live and work in the United States temporarily. The key word there is temporarily. In 2025, the Trump administration has terminated TPS designations for multiple countries. Afghanistan, Cameroon, Haiti, and Burma, also known as Myanmar, have all lost their TPS protections. And if you're from Haiti or Venezuela and you still have TPS, here's the bad news. Your timelines have been drastically shortened. The expiration dates have been moved up significantly compared to what they were before. This isn't something that's going to affect you next year or the year after. This is urgent right now. If you're a TPS holder, you need to act immediately. Don't wait until your status expires to figure out what to do next. You need to be consulting with an immigration attorney today to explore alternative pathways. Maybe it's asylum, maybe it's adjustment of status through a family relationship. Maybe there's another form of relief available to you. But you need to find out now, not later. Let me be crystal clear about this. The window to act is closing fast. Every day you wait is a day you're losing. Don't be the person who wakes up one morning and realizes their protection has expired and they're now in removal proceedings. All right, let's move on to something that's affecting workers across the country. Work authorization. if you have an employment authorization document, an EAD, or work permit. This next part is critical. Here's what changed. For years, when you filed to renew your EAD, you would automatically get an extension of your work authorization while USCIS processed your renewal. This was a lifesaver because it prevented gaps in your ability to work legally. But guess what? That automatic extension has been eliminated for most categories for applications filed on or after October 30th, 2025. Now, why is this such a big deal? Because USCIS processing times for work permits are currently exceeding 6 months in many cases. 6 months. That means if you don't plan this perfectly, you could be sitting at home for half a year without legal authorization to work. No work means no income. No income means no rent payment, no car payment, no food on the table. So here's what you absolutely must do. File your EAD renewal at least 180 days before your current work permit expires. That's 6 months. Don't wait until the last minute. Don't file 3 months before. 6 months minimum. This gives you the maximum buffer against processing delays and helps ensure you can keep working without interruption. Now, if you're an F1 student with DACA status, I do have some good news. A federal court blocked the administration's attempt to end automatic deferred action grants for special immigrant juvenile status applicants, so USCIS must continue automatically considering SIJS youth for deferred action and work permits. But let's be real. The future of DACA itself is still hanging by a thread. Legal challenges are ongoing, so even though renewals are still open as of late November 2025, nothing is guaranteed long term. Now let's talk about something everyone wants to know. How long is this actually going to take? Processing times in 2025 are frankly brutal. Even though USCIS made some improvements in 2024, most categories are still facing lengthy delays, and some are actually getting worse. Let's start with family-based immigration. If you're filing Form Y-130, the petition for alien relative, buckle up. For immediate relatives of U.S. citizens, that's spouses, parents, and unmarried children under 21, you're looking at processing times ranging from 17 to 65 months. That's right, 1.4 to 5.4 years just for USCIS to process the initial petition, not the total time to get a green card, just the petition approval. And if you're not an immediate relative, the numbers get even more painful. Permanent residents petitioning for their spouses and unmarried children under 21 are facing 55 to 89 months. That's 4.5 to 7.5 years. Unmarried adult children over 21, 52.5 to 134.5 months. Married children, 51 to 178.5 months. And if you're a U.S. citizen trying to bring your sibling, 72 to 156 months. That's 6 to 13 years. And here's the kicker. These numbers only represent how long USCIS takes to approve the petition. They don't include the additional waiting time for visa availability based on annual numerical limits and per-country caps. So if you're from India, China, Mexico, or the Philippines, the total time from filing to actually receiving a green card can be significantly longer. We're talking decades in some cases. For adjustment of status applications using Form I-485, family-based cases are currently averaging 8 to 10 months at many field offices, though this varies widely by location. Employment-based adjustment cases depend heavily on visa bulletin movement and how long it took to get your labor certification and I-140 approval. Now here's a bright spot. Naturalization applications on Form N-400 have actually seen impressive improvements. The national median processing time has dropped to approximately 6.1 months. That's the fastest it's been since 2016. So if you're eligible to naturalize, now is actually a good time to file. But if you're planning to bring your fiancé to the United States, I've got bad news. Fiancé visa petitions on Form 1129F have seen processing times increase notably in 2025. You're now looking at 8 to 11 months just for the USCIS approval phase, and then you have to factor in additional consular processing time for the actual visa issuance, which adds several more months to the total timeline. So plan accordingly. Now let's talk about the elephant in the room, the H1B visa program. This has been at the absolute center of immigration policy debates throughout 2025, and if you're hoping to work in the United States in a specialty occupation, you need to understand exactly what's happening here. The H1B program is essential for U.S. employers who want to hire foreign professionals in fields requiring specialized knowledge. We're talking technology, engineering, healthcare, scientific research. These are the jobs that drive the American economy. For the fiscal year 2026 H1B cap, The registration period ran from March 7th through March 24th, 2025, and this year brought some massive changes. The biggest shock? The registration fee skyrocketed from $10 per registration to $215 per registration. Yes, you heard that right. A 21-fold increase. The stated reason is to reduce frivolous registrations and generate revenue for enhanced program integrity measures. But the practical effect is that it's now significantly more expensive for employers to participate in the lottery. The beneficiary-centric selection process that started in fiscal year 2025 continued for 2026. Under this system, selections are based on unique beneficiaries identified by their passport numbers rather than by individual employer registrations. So even if 5 different employers register you, you're only counted once in the lottery. This was designed to reduce gaming of the system and make the process fairer. And the results? The fiscal year 2026 lottery saw approximately 339,000 eligible unique beneficiaries, compared to 442,000 in fiscal year 2025. That's a 26.9% reduction in total eligible registrations. USCIS says this decline is due to the beneficiary-centric process and increased fraud enforcement efforts that have deterred attempts to game the system. But here's the change that could completely transform the H1B program. In September 2025, the Department of Homeland Security published a proposed rule that would fundamentally change the H1B lottery from a random selection process to a weighted selection system based on wage levels. Here's how it would work. H1B registrations would be weighted according to the prevailing wage level of the offered position. Wage level 4 positions, the highest paid, would be entered into the lottery 4 times, level 3 positions 3 times, level 2 positions twice, and level 1 positions, the entry-level jobs, only once. What does this mean in practice? DHS estimates a 48% decrease in selection probability for level 1 wage registrations, a 55% increase for level 3, and a 107% increase for level 4. That's more than double the chances for the highest paid positions. The public comment period for this proposed rule closed in October 2025, and if it gets finalized, it would likely apply to the fiscal year 2027 H1B cap season beginning in March 2026. So this could be in effect very soon. This proposal has sparked fierce debate. Supporters say it prioritizes highly skilled, highly paid workers, which is what Congress intended. Critics argue it would disadvantage entry-level positions, hurt rural employers in certain industries, and potentially inflate wages artificially without reflecting actual market conditions. But wait, there's more. A presidential proclamation issued effective September 21, 2025, requires employers to pay a $100,000 application fee for each H-1B petition, $100,000 per petition. This extraordinary fee increase has created massive financial barriers for employers, especially small and medium-sized businesses, and it's raising serious questions about the future accessibility of the H-1B program. Now, if you're an international student on an F1 visa, let's talk about what 2025 has in store for you. There have been several important developments, and not all of them are bad. Here's some positive news. The cap gap period for F1 students transitioning to H1B status has been extended. Previously, the cap gap extension was only valid until October 1st of the year, for which H1B status was requested. The new rule extends this automatic extension until April 1st of the following calendar year. That's an extra 6 months of stability while you're waiting for your H1B status to begin. And here's something crucial to understand. Optional practical training, or OPT, remains available and unchanged because it's established by statute, not by executive policy. Only Congress can modify statutory visa categories like OPT. So students should continue to apply for OPT and STEM OPT extensions according to normal procedures. But here's where you need to be careful. Visa appointment scheduling at U.S. consulates abroad is backed up significantly. F1 student visa appointments in India are currently booked until early December 2025, and other countries are facing varying wait times. If you're planning to study in the United States, apply for your visa as early as possible to account for these scheduling delays and processing times. Now let's talk about something that requires very careful attention: travel restrictions. During the first Trump administration, we saw a travel ban that affected citizens of several countries, including Iran, Libya, North Korea, Syria, Venezuela, Yemen, and Somalia, with later additions of Kyrgyzstan, Nigeria, Myanmar, Sudan, and Tanzania. Immigration experts are warning that similar travel restrictions could be reimposed or even expanded to potentially include citizens of China and India. While no new travel ban has been formally announced as of late November 2025, anyone from previously affected countries or countries that might be added to such restrictions should think very carefully about the timing of any international travel. Here's the general rule. If you have pending immigration applications or uncertain status, consult with an immigration attorney before making any international travel plans. Even a brief trip outside the United States can create complications for pending applications, or in the worst case scenario, prevent you from re-entering the country. Don't take that risk without professional advice. Let's talk about asylum and refugee programs. These systems have undergone substantial changes in 2025. The administration has significantly curtailed access to asylum at the southern border, and asylum applications can no longer be submitted at ports of entry through the previous processes used during 2025, the Biden administration. However, individuals who are already physically present in the United States can still file for affirmative asylum using Form Y-589, provided they file within 1 year of their last entry to the country. There are limited exceptions to this 1-year filing deadline for changed circumstances or extraordinary circumstances, but these exceptions are difficult to prove. The U.S. refugee admissions program has been substantially curtailed with a formal suspension pending new reporting requirements and policy reviews. This has created significant uncertainty for refugees awaiting resettlement and for the agencies that assist with refugee services. If you already have asylum or refugee status in the United States, your status remains valid, but you should be aware of the restrictions on public benefits I mentioned earlier, and you should consult with legal service providers about your specific situation. All right, so we've covered all these changes. Now let's talk about what you actually need to do about it, because information without action is useless. Number 1. If you have any immigration status that requires renewal, whether it's a work permit, travel document, green card, or other documentation, file for renewal as early as possible. With processing times at or near record highs and automatic extensions eliminated for many categories, early filing is your best protection against gaps in authorization. Don't wait. Do it now. Number 2. If you have temporary protected status, consult with an immigration attorney immediately to explore alternative legal pathways. Not next week, not next month, today. Don't wait until your TPS expires to begin this process. Many alternative pathways have their own eligibility requirements and timing considerations that require early action. The earlier you start, the more options you have. Number 3. Gather and organize your documentation right now. Whether you're planning to file an application soon or might need to file in the future, having organized records will make everything smoother. I'm talking about tax filings, employment history, residential addresses, travel history, identity documents, all of it. Processing delays are often caused or extended by requests for additional evidence, and complete initial applications move faster. Get ahead of this. Number 4. If you're an employer considering H1B sponsorship, understand the current lottery odds and the potential for significant changes in fiscal year 2027 if the wage-weighted selection rule is finalized. Begin identifying candidates early and consider alternative visa categories for employees who might not be selected in the lottery. Don't put all your eggs in the H1B basket. Number 5. Understand your rights. Regardless of your immigration status, you have certain constitutional protections. If you are questioned by immigration enforcement, you have the right to remain silent and the right to refuse consent to searches. You have the right to speak with an attorney before answering questions. Knowing these rights can be absolutely crucial in protecting yourself. Number 6. Be extremely cautious about immigration fraud. The complex and restrictive environment we're in right now creates opportunities for scammers and unauthorized practitioners who promise results they cannot deliver. Only work with licensed attorneys or Board of Immigration Appeals accredited representatives. Verify credentials before paying anyone for immigration services. If something sounds too good to be true, it probably is. And finally, number 7. Stay informed, but verify information. Immigration policy is changing rapidly, and misinformation spreads like wildfire on social media and through community networks. Rely on official sources like USCIS.gov, the Department of State, and reputable immigration law organizations. That's exactly why Dream Visa Updates exists, to give you accurate, verified information you can trust without the panic and sensationalism. So what should you expect as we move further into 2025 and toward 2026? Let me give you my honest assessment based on current trends. Enforcement-focused immigration policies will probably remain in place throughout the current administration. That's just the reality we're dealing with. Processing times may improve gradually as USCIS continues backlog reduction efforts, but with 11 million pending cases, significant improvements are going to take time. Don't expect miracles overnight. The H1B wage-weighted lottery proposal may be finalized and implemented, which would fundamentally change the calculation for employers and prospective H1B workers. If you're planning on H1B sponsorship, you need to be preparing for this possibility right now. Additional countries might be added to travel restriction lists. More changes to public benefits access for immigrants are likely. And despite ongoing discussions about legislative immigration reform, including bills like the DREAM Act that would provide a pathway to permanent legal status for certain long-term undocumented immigrants, meaningful reform remains unlikely to pass in the near term given the political divisions in Congress. What all of this means is that careful planning, early action, complete documentation, and professional legal guidance are more important than ever. The immigration system has always been complex, but the combination of policy changes, processing delays, and heightened enforcement creates an environment where small mistakes can have serious, life-altering consequences. Look, I know this information is dense. I know some of it is concerning, maybe even scary. But here's the truth. Understanding the actual situation is the first step to navigating it successfully. Knowledge really is power when it comes to immigration matters, and you now have the knowledge you need to make smart decisions. If you found this video helpful, please give it a thumbs up. It helps more people find this information. And if you haven't already, subscribe to Dream Visa Updates. We're committed to bringing you accurate, timely updates about U.S. immigration policy without sensationalism or fear-mongering. Just the facts you need to make informed decisions. Hit the notification bell so you don't miss future updates, because immigration policy continues to evolve, and I'll be here to break down every important development as it happens. If you have questions or topics you'd like me to cover in future videos, please leave them in the comments below. I read every single one. Now, before I go, I need to say this. While this video provides information about current immigration policies and procedures, it is not legal advice. Every immigration case is unique, and if you have specific questions about your situation, you should consult with a qualified immigration attorney who can review your individual circumstances and provide personalized guidance tailored to your needs. Stay informed, stay prepared, and stay hopeful. The path through the U.S. immigration system may be challenging right now, but with the right information and proper guidance, you can navigate it successfully. Remember, thousands of people are successfully moving through this system every single day. Even with all these challenges, you can be one of them. Until next time, this is Dream Visa Updates. I'll see you in the next one.